Ready? 3, 2, 1, start. The factual matrix of the case is that RSS and Vishwa Hindu Parishad had called for a strike stop. The strike led to clashes between members of the Communist Party of India and RSS stop. A group of 11 persons hid and stayed near a shed which was situated near the river stop. At midnight, they saw 11 persons coming towards them and they were carrying deadly weapons like axe, dagger, and chopper. Stop. They rushed towards the river to save themselves. Stop. The two deceased were asleep and thus the mob given fatal injuries to them. Stop. The inquest of both the dead bodies was conducted and inquest reports were prepared. Stop. Subsequently, postmortem was done on the same day. Stop. It is pertinent to note here that though one Ashraf was named in the FIR as A13, but later on a report for deletion of his name was moved before the magistrate stating that Ashraf was undergoing treatment at Mangalore on the date of incident. Stop. Magistrate has only noted the date of FIR and did not note the time. Stop. The prosecution has failed to examine the handwriting of the person who had noted the time of the FIR. Stop. It was submitted that the prosecution has tried to implicate innocent persons, and the same can be seen from testimonies of eyewitnesses who gave their statements about Ashraf being present on the spot of the alleged incident. Stop. Further, it was argued that there is violation of statutory provision of section 154 of the Code of Criminal Procedure 1973 as the FIR came to be lodged belatedly. Stop. It was stressed upon by the learned counsel for the appellant that Sunil was murdered elsewhere and the body was brought to the scene of occurrence to implicate the appellants. Stop. It is further submitted that the recovery made under section 27 of Indian Evidence Act is not credible. Stop. It was contended that a prudent man would mention a police jeep as a police jeep itself. Stop. It was submitted that the doctor had not recorded the names of persons who brought the dead body to him, and he was the same doctor who had examined the dead body. Stop. As per the appellants, the body of Sunil was found not even close to the river, and as such, there cannot be any high tide. Stop. The eyewitnesses could not have seen the incident as alleged because of the obstacles such as heap of coconut. Stop. It was vehemently argued that inquest report was not made properly and the eyewitnesses were giving parrot-like statements only to implicate the accused persons due to political enmity. Stop. It was submitted that it is an improbable human conduct for the eyewitnesses to keep standing when a bomb is being thrown at them, and despite of this they were not fleeing from the spot, and that the recovery of bomb was not made in a proper manner. Stop. On the other hand, learned standing counsel for the state argued that the judgment passed by the High Court is a very well reasoned judgment. Stop. The High Court has rightly convicted the accused persons on appreciation of evidence, and the appeal of the appellants needs to be set aside. Stop. Crime creates a sense of societal fear and it affects adversely the societal conscience. Stop. It is inequitable and unjust if such a situation is allowed to perpetuate and continue in the society. Stop. In every civilized society, the purpose of criminal administrative system is to protect the individual dignity and to restore societal stability and order and to create faith and cohesion in the society. Stop. In the discharge of their duties, the courts are tasked with balancing of interests of the accused on one hand and the society on the other. Stop. Having said this, let us consider the evidence on record to see as to whether the High Court has appreciated the evidence in a proper manner to partly allow the appeal. Stop. Admittedly, there was a long political rivalry between RSS and Communist Party of India. Stop. As has been stated by PW1, he and 11 others were earlier a part of Communist Party of India and they had defeated and joined RSS and hence there were bad relations between the two groups. Stop. Admittedly, a call of strike was given by one organization and the same was opposed by another political party, and this led to a clash between the followers of these two parties. Stop. The version of witnesses discloses that the group of 11 members rushed to a shed near river to save their lives from the violent mob. Stop. This group of 11 members was hiding themselves near the river, and in the night, the accused persons led a deadly attack on them, and ultimately, two persons lost their lives as a result of this incident. Stop. It was argued by the counsel for the appellants that there are material contradictions in the testimonies given by the prosecution witnesses, particularly the eyewitnesses. Stop. In this context, the question arises whether these contradictions are material enough for the benefit of doubt to be given to the appellants so as to set aside their conviction. Stop. The law relating to material contradiction in witness testimony has been discussed by this court. Stop. In the trial court, it is common practice to make out contradictions from the previous statements. Stop. Since there is inconsistency in evidence, it is not sufficient to impair the credit of the witness. Stop. No doubt there is the provision in section 155 of the Indian Evidence Act which provides scope for impeaching the credit of a witness by proof of an inconsistent former statement. Stop. A plain reading of this provision would indicate that all inconsistent statements are not sufficient to impeach the credit of the witness. Stop. Even if the defense is successful in contradicting a witness, it would not always mean that the contradiction would result in totally discrediting this witness. Stop. A mere variation in the two statements would not be enough to discredit a witness. Stop. This has been followed consistently by this court in its other judgments also. Stop. Bearing in mind the above mentioned settled position of law, this court is of the considered opinion that though there is a variance in the statements of the witnesses, it is minor and not of such a nature which would drive their testimony untrustworthy. Stop. This court finds the deposition of witnesses to be honest, truthful, and trustworthy. Stop. Hence, the observations made by the High Court in this regard are well reasoned. Stop. It is worthwhile to mention that in his examination in chief, Jitesh had mentioned that Sunil was not seen. Stop. Nociter a sausus is a well recognized principle which is used for interpretation of the statutes. Stop. It means that the meaning of a word can be determined by the context of the sentence and it is to be judged by the company it keeps. Stop. Though this principle is used for interpretation of words in a statute, but this principle can very well be applied to the facts of the present case, which have to be seen in the context of the entire set of events. Stop. This court is of the opinion that it is a natural human conduct that to save the life of someone, the entire focus in such a situation would be to take the injured to the hospital and not to waste time on giving minute details. स्टॉप वगैरह सब मिला के 124 की स्पीड पे